We will start. Welcome to the First Amendment Salon of 2016. We are very happy that you could all be with us in New York, here in City today. Before I turn it over to my co-chair, Ron Collins, to introduce tonight's program, I wanted to say a few words both about the ground rules for tonight's event and a preview of coming attractions. First, the preview of coming attractions. Our next salon will be on May 16th. Put it on your calendars. It will be actually emanating from the University of Chicago Law School, but it will be simulcast to these two venues as well as to the Yale Law School in New Haven. And it will be a conversation between Professor Jeffrey Stone and Judge Richard Posner, exploring Judge Posner's views about the First Amendment. I am sure you will not want to miss that one. So please put that on your calendars. Invitations will be going out in due course. Now, a word about the ground rules. This will start out as a moderated discussion, and Ron will get into the discussants and the subject matter in a moment. But after a time, we will open the floor to general discussion. The general discussion, as those of you who have been here in the past know, can be in the form of questions to the primary discussants, or it can be comments and dialogue and debate between those of you in the audience and the principal discussants. So please, especially those of you in New York who feel a little removed from the action, please feel free to comment, contribute, ask questions, make comments. That's what makes this thing really work. So with that, Ron, it's all yours.
Thank you, Lee. And greetings to our friends and colleagues here in Washington, D.C., and our friends and colleagues in New York. Always good to see you. Public service announcement before we begin. I'm pleased to say that the First Amendment Salon will be launching a new endeavor. From time to time, we will release occasional papers and briefs. And basically what we're going to do is we will, from time to time, take a scholarly article that we think has some real value to the practicing bar, and we'll ask a prominent First Amendment lawyer to write a preface to that. And then that preface and an abstract of that article will be widely distributed to the First Amendment bar and the First Amendment Academy. And I'm pleased to say that in a couple of weeks, you'll be hearing about a forthcoming article by Professor Eugene Volokh that will appear in the Cornell Law Review called The Speech Integral to Criminal Conduct Exception. I've read it. I think it's one of the most important law review articles I've seen in a long time. And Bruce Johnson from Davis Rice Tremaine in Seattle has kindly agreed to write a preface to that and why that article is important to practitioners. By the same token, from time to time, we plan to take an appellate brief, a merits brief, amicus brief, what have you, that we think is of some exceptional merit and that might be of interest to people in the legal academy. And there we will ask a prominent First Amendment professor to write a preface to that and indicate why he or she thinks that that article would be particularly important to people in the legal academy. All of this is in keeping with what we do here at the Salon in an attempt to bring the legal academy, the practicing bar, journalists and activists all together so we have more application, not easy for me to say, of voices. So stay tuned. That will be coming to you by way of emails pretty soon. And make sure you turn off your phones.
That's like in the movie.
Yeah, right. So I hope he doesn't call back. Anyway, it is my pleasure to introduce tonight's moderator, a longtime friend and colleague, and anybody who is interested in First Amendment law has to be interested in the work that Ilya Shapiro, a senior fellow of constitutional studies at the Cato Institute and the editor-in-chief of the Cato Supreme Court Review. Ilya has filed many briefs in the United States Supreme Court, including many important First Amendment briefs, which have been cited approvingly by the court, by either the majority and or concurring or dissent. He is the co-author of a book published in 2014 called Religious Liberties for Corporations, Hobby Lobby, the Affordable Care Act, and the Constitution. And it is my pleasure to introduce my friend and colleague, Ilya Shapiro, who will introduce tonight's discussions. Ilya, welcome.
Thank you, Ron. I've really enjoyed attending these events, so I was tickled when Ron called me and asked whether I'd be willing to moderate and, get credit for being on the stage, as it were, without really having to put in much hard work of providing the main substance, as the panelists are here, who I'll introduce now. Danielle Citron is the Louis K. Mott Research Professor and Professor of Law at the University of Maryland Francis King Carey School of Law. Her work focuses on information privacy, cyber law, automated systems, and civil rights. In 2005, she received the Teacher of the Year Award. Professor Citron is also an affiliate fellow of the Yale Information Society Project, an affiliate scholar of the Stanford Center on Internet Society, an advisor to California Attorney General Kamala Harris's Task Force Against Cyber Exploitation, and the American Law Institute's Restatement Third of Information Privacy Principles Project. I wouldn't realize that there are already 3 restatements of information privacy principles. That's
No,
great.
the first one ever, but we're under the hub.
Oh, I see.
We've never done it before.
And she has many more accolades. The most interesting that jumped out at me in her bio is that this book that we're talking about today, Hate Crimes in Cyberspace.
Don't you love it, Danielle?
I love that. Golly, never again.
Was nominated in 2014 by Cosmo and Harper's Bazaar as one of the top 20 best moments for women in 2014. There you go. Discussing Professor Citron's book will be Laura Hammond, who's a co-chair of the Davis Wright Tremaine's appellate practice and divides her time between the New York and DC offices. Glad that you're here. No offense to all of you in New York. For 30 years, Laura's been providing pre-publication counseling and litigation services to broadcasters, film studios, and book, magazine, newspaper, and internet publishers and nonprofits. Basically a dream job for anyone, a law student who says that they're really into publishing and First Amendment, and I want to deal with media companies. This is it. You want to get to know her and find out her secrets to get to how she's been. I mean, her list of clients is just incredible. I'll just randomly, Amazon.com, Atlantic Media Company, Bloomberg, China Central Television, Dow Jones, Random House, Yale Alumni Magazine. Well, as a Princeton man, I'll forgive her that. And Yale. Anyway, those are our discussants. Danielle, can you start just by, I will say this book, I don't know if Ron knew this when he asked me, but there are very few subjects on which I have no preconceived opinions about. This is one of them. When I got this book, I was like, I've heard of, I know revenge porn is out there. I know stalking, cyber stalking. No idea what the laws on any of this stuff is. No idea what problems might be, what reform efforts might be. I could, hypothesize First Amendment issues like a law school exam or something. But anyway, I'm very glad to be educated by your book, Danielle. So why don't you start just by talking about what motivated you to write it and the main themes that you're trying to get across or put into the public discussion.
So I started working on the question of cyber harassment and cyber stalking in 2007. There were some sort of big high-profile attacks on Kathy Sierra. I don't know if anyone knows who she's a tech blogger at the time. And she was targeted on her blog and a number of group blogs and graphic threats of violence on the comments on her blog, doctored photographs of her that looked like she's being strangled with lingerie. There were photos of her that were doctored that had comments like with a noose, an actual noose here next to her picture. Really her neck size. She talks about, she tackles a speaking engagement in San Francisco, and she writes about it on her blog. And as soon as she writes about it, there is a campaign, sort of a second campaign of abuse that her social security number, home address, sort of a story of defamation about her life, accusing her of being a prostitute at the bankrupt stage, of having affairs and plastic surgery all over the internet. And the reason as individuals who were spreading the story about her and her involved with the social security number and information was that she was whining about being targeted with rape threats, death threats, the doctored photographs. But how dare she whine about being explicitly threatened so graphically that she had to be taught not to whine anymore. And so much of the kind of story about this attack on Kathy Sierra was that it's the Wild West, folks, get over yourself. like, Kathy, stop making such a fuss of this, ignore it. You know, she was told to turn her computer off, and so, you know, I write about,
Just trying to get the microphone a little closer to you so they can hear.
oh, sure.
Are you having any issues hearing in New York?
Yes.
Okay, okay. So is it here?
Thank you for asking.
We'll move this, so we'll do two things. We'll move this a little closer and ask you to.
Great.
No wonder they laughed at my hilarious introduction.
Is that, Daniel, let's do it.
That better?
Daniel?
Right, so Julia asked me what motivated me, what started me on this work. And then, so I was talking about how in 2007, there were some prominent attacks on women, both in the tech blogosphere as well as law students on various message boards. And the attacks were often brutal. We had, there were rape and death threats, really graphic rape and death threats. Often the abuse was accompanied by defamation, so accusations that someone had a sexually transmitted disease or that they were interested in anonymous sex and their home address and various personal information would be provided. Privacy invasions would often accompany the stalking and harassment, so nude photos or doctored photographs that make it look like someone was nude and was interested and available for anonymous sex. And sometimes the abuse was accompanied by sort of technical attacks, so distributed denial of service attacks designed to shove people in silence and push them offline, false reports of abuse in the attempt to have providers sort of, you know, turn off people's profiles. And at the time, so this is 2007, 2008, the response was often by law enforcement to victims when they went to law enforcement was just boys will be boys. It's no big deal. Just ignore it. It will go away. And this kept happening more and more. Victims were told sort of very similar pattern, a sort of perfect storm of abuse, often sort of death threats, privacy invasions, defamation, often technical attacks. And it was like an endless loop as victims sort of got in touch with various of us who were involved in privacy and academia. And the response so often was, just ignore it, it'll go away. When in fact, of course, for victims, it can't go away. When a Google search of your name prominently lies at you, the suggestion that you're interested and available for sex on like adult finder sites, your nude photos or doctored photos, and you can't walk away from it, right? Employers aren't walking away from it, right? And individuals were losing, you know, tangible life opportunities, the ability to work, to engage online. Kathy Sierra, I talked about her earlier, so folks who didn't hear, but people shut down their blogs. They were shoved offline with technical attacks, but they kind of retreated, right? Because the more they stayed online, the more it was sort of provocative, right? And the more they retreated, the attacks would sort of subside. And as I started writing about it, I understood all of this because so often the victims were women, and the attacks so gendered and sexually humiliating. And so men experience stalking and harassment as well. It often lines up in the same way. So it's not just threats, it's threats of anal rape, right? It's not just any old lie, but the suggestion someone has AIDS, HIV, herpes, right, is a prostitute. And the privacy invasions were often very sexual, that is nude photos, right, and the suggestion that someone was available for sex. And I understood all of this, at least as kind of the new frontier of you know, interferences with our civil rights, right? That is so often we've been talking about fundamental civil liberties, but we were sort of neglecting, I think, an important story about how we were using network tools not as liberty-enhancing ways, but in ways to deprive people of their liberties, right? Their ability to live free from harm, to work, to get jobs, to engage as, you know, as journalists and make a living online, right? In all the ways that we need to. So that's what the sort of criminalization of online abuse is what sort of launched me into this project. And the hope in this book was to, I think, really carefully carve out like an understanding that law can do something here. That is, we don't have to write a whole new slew of laws. So often I talk about this, people say, oh, we've got to pass all these new laws, and that's not true. We have laws on the books that we can deploy to combat much of stalking, harassment, threats. and some civil rights violations. There's reforms we need to engage in, of course. But I think an important part of this story is that law enforcement, to teach them that there are laws we can use right now. We don't have to completely rewrite the state statutes and the U.S. code. We've got to be educated about them. And I wanted to, as best that I could, and in the most nuanced way that I could, create an agenda that would comport with First Amendment doctrine and First Amendment theory. That is, I'm modest in my sort of demands of the law, because I consider myself a civil libertarian, though, I have friends with the ACLU and UFF. I feel like I'm one of you. I promise, right, that, when I first started talking about all of this work, people would say, like, are you trying to break the internet, Danielle, and I really wasn't. I've tried to be as careful as I can be. And in the last year and a half, I've been working with A.G. Harris in California to educate law enforcement. I've been working with companies since 2009 to think hard about their terms of service and community guidelines, and to urge them to be as careful, thoughtful, and clear about what they mean by terms like harassment and stalking, and to, if they're going to remove speech, to let their users know and give them a chance to object and provide modes of redress, because platforms are so powerful. So the book is, I tackle law and what law can do, within the confines of the First Amendment, and what companies are doing and what they should be doing better, to ensure that they're so indispensable platforms to our communication. So that's the hope of the book.
Just so we're on the same page, and before we get to reform proposals or new laws, talk about existing law and what, because part of it, there seems to be a theme throughout the book that the police just didn't know, or, one officer just had never heard of Twitter, for example. I imagine it's 2 years ago, not like right now, but
not that long ago, in 2012.
Okay.
And now the Heffers.
Just didn't think that anything online was even applicable in his jurisdiction, in his bailiwick, as it were. But here, lo and behold, there's the federal stalking and harassment laws, which you say captures a wide range of online abuse. So talk about this existing law. Well, that's the federal one, but whatever this kind of general state mode is as well.
Right. So, and a lot of my sort of suggestions are geared at the states. They're the beginnings of stalking and harassment law came from the states. So in 1990, California passes the first stalking and harassment law. Within 3 years, every state follows. They are, the federal resources are incredibly limited. Whenever anyone goes to federal law enforcement, the response is, it's not national security, we have no help for you. And it's understandable, right? In a world of limited resources, California has 20,000 peace officers or police officers vis-a-vis what the FBI's resources available. But so we have stalking in about half the states. There are stalking and harassment laws that address the targeting of a specific person with a harassment, a course of conduct, which has a distinct meaning in the law, with an intent to harass or intimidate that does in fact cause severe emotional distress and or the fear of physical harm. And these laws have been, so we have to say they're pretty well-designed laws that as applied have been upheld, usually in cases in which you have this perfect storm of largely unprotected speech, so true threats, defamation, the publication of social security numbers, or what we're calling revenge porn, but really the non-consensual distribution of nude photographs of individual private individuals, right? So not Hulk Hogan, right? Just the ordinary person. I didn't say that.
We'll get to him and
we'll get there, right?
And all that.
Right. But normally, it's an ordinary person, right? And so we do have laws we could deploy, but so often they're just left on the books. They're underutilized. It's true that about half the states we have laws that are really they're drawn to address. They're called email harassment laws, telephone harassment laws. They don't capture abuse that. So, for example, case from New York, they only cover direct communication, so one-to-one communication, victim defendant. And so, case from New York, a boyfriend posts. There's a breakup. Defendant posts a nude photograph of the ex-girlfriend that was shared in confidence and with an expectation of privacy. On Twitter, he sends them to her employer, to all of her, I think she's a drug wreck, so all to all of her clients, and to her family sends her threats as well. And some of it is, most of it's on like sort of public pages, so that it's not sent directly to her. He's indicted, but it's dismissed, and rightly so, because the New York law only covers one-to-one communications between the defendant and the victim. We've got to catch these laws up. They shouldn't be technologically either bound to email, which many of us don't use anymore, but even if we did, they just aren't capacious enough. So we've got some work to do at the state level. And we've got threat laws on the books, many with intent requirements, right, post Salon. We have sort of laws that have been upheld, threat laws on the books. So we have extortion, solicitation so often. People will impersonate individuals on adult finder sites or on sort of porn sites and suggest that they're false ads and suggest someone is interested in rape fantasies and provide all of their home, their home address, when they will be home, their contact information. And we can understand that as a form of solicitation. So there are criminal laws that we can bring to bear now against these youth. And we have the federal cyberstalking law, 18 U.S.C. 2261A, which, it sort of could be a template for other states. It's very well designed, crafted. It covers, the targeting of an individual with a harassing course of conduct with strong intent requirements and proof of fear of physical harm and or substantial emotional distress. And they've been prosecutions under 2261A have been upheld.
Laura, how do you see these problems that Danielle's identified, and what do you think about the laws that she discussed?
Well, I'm going to start with my own story. As some of my colleagues know, I have been a victim of cyberbullying. And so I come at this with a less doctrinaire view than you might think from the bio that Ilya described. It began, I was representing a newspaper, a lawyer representing a client who didn't like the newspaper's coverage, complained. I responded, and that then led me to be the subject of attack on the client's website, everything from my curly hair to my credentials to my husband, and most offensive of all, putting comments in my name on his comments page, comments that I never made. I'm being deliberately vague because I don't want to invite his attention. And I am engaged in the kind of self-censorship that Danielle describes in her book that is a result of cyberbullying. And in the course of the work there were multiple times when the lawyer contacted me about coverage, and I made sure that the associate's name was nowhere to be found in any of the communications because, as you say, this has much more of an impact on someone beginning their career than someone whose career is already established. I asked the lawyer to ask his client to take this down. The result was worse, and he said, I have no control. And I said to the lawyer, then you need to look to your own conscience, and ultimately he was replaced, and new lawyers took his place, of course. I did think about libel suits, as some of my colleagues know, and of course I know better than anyone how difficult a plaintiff's libel suit is, and how very awkward it would be for someone like me to bring one. I did think about false impersonation, which he engaged in by putting comments in my name. But I knew that no one who knew me or knew of me would ever think I would have made those comments, and indeed I've never posted a comment in my life anywhere. I am not in the social media world for good reason. He did use my picture from the firm website, and I thought about a copyright claim, but he did write over my picture things like racist and guilty of being ugly, so arguably it was a transformative use. He did put famous celebrity in a very seductive picture next to me in order to, of course, attract clicks, because people are not looking for me, they're looking for the celebrity. But getting Google or anybody to sort of not be susceptible to those kinds of tricks is pretty useless. So you say, well, what are the remedies? And I don't think the remedy is to expand criminalization of speech. And the Alonis case, I think, was a good example of where someone, a rapper, posted rap lyrics that were very violent. It wasn't a one-to-one communication, it was a one-to-many, as Professor Balko described. And the Supreme Court said it's not enough that a reasonable person would view this as a threat to them. He has to have intended to threaten his soon-to-be ex-wife. And I had some firsthand experience with this, representing a small-town paper, which very much functioned, their website and blog functioned very much as a virtual town square. And there was a great controversy at the time about the school superintendent, who ultimately resigned. And lo and behold, the small-town newspaper got a grand jury subpoena, wanting the IP address of someone who posted on the blog some pretty obnoxious comments, including posted anonymously that the superintendent should be worried when she was stopped at a traffic light. And the judge in Goshen, New York, not a place you would think would be a hotbed of First Amendment thinking, asked the prosecutor, so is the grand jury investigation based on speech and speech alone? Is there evidence of any crime? If you saw evidence, I didn't see it. And then he said, assuming you can translate the post from the moron who wrote it, it's still only speech. And he quashed the subpoena, did not require us to reveal the IP address, which in a small town where you're writing about a superintendent and there could be retaliation, be it if you're a parent or a teacher or a student, the anonymity actually does matter. But the judge said, as the publisher who was there was leaving, you got to police that blog. And that, honestly, is the remedy, and that, I think, is what you're saying. That part of the First Amendment exercise of speech is the right to decide what you want on your blog. And I think that is the example of where, you know, she could think about, well, maybe I don't want that offensive comment on my small town paper blog and the terms and conditions that you were mentioning. And I saw where Microsoft recently said they've taken down 67% of the revenge porn requests that they've asked for takedown. And then they look at the others and they say, well, there's not really nudity, or, well, the victim's not really identifiable, or we don't know enough about the sort of background. But they take the time to make those decisions. I also don't think, and Danielle talked about this a little bit, cutting back on the Section 230 protection for websites for third-party content is the solution. We want to encourage the websites to curate, to take down, to move to the bottom of the pile those comments that they think are less worthy without jeopardizing the protection that they've been given. The trade-off might be that, you know, if someone could show that there was a prima facie case of libel, then in exchange for having that protection, if you're the website, maybe you decide to reveal the poster so that there is a remedy by the person who's defamed. Or you do what TripAdvisor does. Obviously, their model
Also one of her clients.
their model is crowdsourcing, so you get to see there's, you know, the raft of comments, and you can evaluate what you think is, you know, rings true, and also they give you actually information about the reviewers. You can see, well, this person gave negative reviews to every place he went. I'm not going to really credit what he said about the dirtiest hotel. So I think it's, you know, those are the solutions. I think if you think about the dirty website, it poses a lot of these questions. The dirty got a post of Anthony Weiner's sexting from the woman who received the post. Was that newsworthy? Yes. Did it lead to his resignation from Congress? Yes. Did it violate his privacy? In my judgment, no. A closer question was the highly offensive comment about the Cincinnati Bengal cheerleader turned school teacher. But there again, the Sixth Circuit said that the editor of that site did not materially contribute to the defamatory content, even though he said he added his own comment, why are all high school teachers freaks in bed? That was not an adoption of the comment. It didn't alter the comment, materially contribute. So I think the bottom line is the line drawing is excruciatingly difficult, but it should not be, in my view, most often at the point of an indictment or a threat of liability.
And Danielle, Laura says that part of what you may be doing is criminalizing speech. Are you calling for criminalizing some of these sorts of speech, or is it all fitting this bad stuff into different categories like defamation or solicitation of criminal activity or disclosing the non-consensual porn? Is that some sort of new category? Is that some sort of fraudulent, without consent sort of thing? So talk to us about new and old categories.
So,
Okay.
I think my reform agenda is designed to only address speech that falls within either existing categories or speech that historically has been provided less rigorous protection. So let's take the example of revenge porn, right? Criminalizing the non-consensual publication of nude images, knowing that the person shared them in confidence or with an expectation or reasonable expectation of privacy, with an of course an exception for matters of touching on matters of public importance. I think Barton gave one of my favorite cases that I think will definitely
One of my favorites.
right? Yeah, for all that.
Would you repeat that for the New York audience?
Yeah, it's lovely, and Barton versus Foster. I'm very humbled to be here with all of you too. But Barton cases of that, and I realize it's difficult, but when it comes to certainly the publication of truthful information about matters related to the public interest, we can't punish that speech, right? But when it comes to purely private matters, and the court talks about in DECA, domestic gossip, right? That we have privacy protections in the Wiretap Act. It's largely electronic communications. Why? Because it fosters private speech. As the court underscored that we have speech on both interests on both sides of the equation, right? The punishment of or remedy for the disclosure of private facts related to purely private matters, that of course hinges on free speech, right? But at the same time, you have free speech interests that is individuals who are communicating, frankly, are not going to communicate if they think all of their communications, electronic communications or wire communications, are going to be for public communication. The court recognizes that there's speech on both sides of the coin, right? Revenge porn statutes or the criminalization of the non-consensual, the disclosure of non-consensual pornography is the kind of speech that is it's private communication, but if we didn't have these protections, right, people aren't going to share them with each other. There's no sense of confidentiality or privacy. This is what happens when I'm 47 years old. Look, I'm not sharing these photos with my spouse, right? But I have high schoolers who I say you can't do it unless you're over 18 because it's child pornography, but assuming after they turn 18, right, which is soon enough, right, they can do that. It's a form of intimate expression, and I hope that if they do it, they have conversations about confidentiality and privacy, and that if they do it, it's a form of expression.
How do you define the private information?
And how does the statute define it, or
Well, how does the statute define it, or how would you define it? Because what counts as personal, private, or so intimate that the sharing of that is or should be?
so,
Because I can share lots of embarrassing things that aren't,
sure.
sexual or domestic.
Absolutely, and we've got to be really clear about the kinds of images we're talking about, so not embarrassing images, not offensive images, but nude images. So I'm going to take some of them where I find them.
You see it's dog-eared and underlined, I've read it.
I know, right? Really,
Put a whole right out to
happy, right? But, I mean, I think we can define nudity and nude images with enough clarity, and we do elsewhere, right? Videos where anymore, right? We have and have that as,
So it's just that sort of thing. What if it's, what if I'm having beers with Ron
right,
and, well, no, I would never do this. What if my wife were having beers with Ron and starts complaining about me, right? That would be embarrassing if Ron publicized that on the next issue of First Amendment News.
sure, it's embarrassing, but totally protected speech, even though, well, you're not both purely private individuals, or both, right, public figures.
No, I'm definitely not a public figure.
Right on, okay.
My wife's not.
I'm totally private figure.
But that's gonna be protected speech under the sort of Bartnicky, that is, you're talking about public figures and matters of public interest, it's embarrassing, but.
Take away the public figure to the whatever extent I may or may not be, but let's say, it's not, the public figure isn't an issue. And, two people are chit-chatting, exchanging really embarrassing things about each other, about their families, whatnot. No nudity involved, not even sexual peccadillos. We're not talking about who has venereal disease or anything like this, but just embarrassing things, and that gets out.
Right, so it's protected speech, and so we know that the tort of public disclosure of private facts is incredibly narrow. It probably will only sanction civil remedies where you have like a social security number that is virtually like a key to your bank account, right? And I think nude photos are the sort of the most sacred of sacred things, that really there's nothing that's newsworthy about them. There's no cultural significance. Okay, Hulk Hogan, let's just put that for aside. Okay, and Anthony Weina's cross chops, can we put that aside? Because I do in my book.
Can we please?
That's newsworthy. I see that, right? But like these private individuals I write about in my book, right? I think we can, that the tort, and then to the extent that there is the criminalization of something like non-consensual pornography, ought to be incredibly narrow, right? For speech that has, with just so little light on what we think of as self-government, or even personal self-expression, or the pursuit of knowledge. And all the reasons why we protect speech on security numbers and nude photos, we jeopardize
So that's
little.
not unprotected speech. That's not kitty porn. That's not defamation. That's not, this is just less protected speech that has certain time, place, manner restrictions around it, sort of.
Or that the court has said, too, that as a historical matter, there are also, even though it doesn't fall within a category of speech, like the Stevens, sort of these are these categories, but the court also notes in Stevens that there is speech that we, as a historical matter, have allowed, including intentional infliction of emotional distress about purely private matters and private individuals. The court's been invited to strike down the tort in Falwell, in Snyder versus Phelps, and hasn't taken the invitation, right? It has clarified when we can have that, a claim for intentional infliction of emotional distress. And the court has never struck down the public disclosure of private fact tort. And I think in Bartnicky, we can sort of assume that the tort is alive but incredibly narrow.
What's wrong with that?
Well, I mean, first of all, in terms of the categories of speech, nudity is not unprotected. Obscenity is, right, but not nudity. And so it's only in the context of where there is an intent to do harm and non-consensual that you're describing. But, the actual speech part of it is not unprotected. And the court has been very clear that they don't want to create new categories of unprotected speech. And I do think, that what is newsworthy, as we've seen just in Florida recently, has people have different views on that. I've been waiting for the hypothetical that you will probably use in your class when the Trump sex tape comes. And will it be newsworthy just by virtue of the fact that it's would it be newsworthy if he said something misogynist on it? Because that's another rap.
Yeah.
If he behaves in a misogynist way. These will be, I think there's a whole range of how you define newsworthy. I mean, Bartnicky, was thanks to Lee that they actually found that was newsworthy. It was kind of borderline, you might say. But it's clear that they have Lee, you're being it's clear that, I think I would have a very broad definition of what's newsworthy. I'm not sure it will agree with your,
And, I mean, one interesting thing too is, so Eugene Volokh has, had public discussions, but also talked to me about how he understands non-consensual pornography as offending. That is, the framework would certainly understand this as obscene, that the non-consensual piece of this movie is what, for him, turns it into obscenity. And I kind of resist obscenity just as a category, because it's so smushy as it is, and community standards.
That's one definable thing. If you
Right.
accept that, that's an
Right,
actual
no, that's
definable
true.
type of obscenity.
That's true, and I guess the reason why I think of this as privacy and that the kind of speech that, because it is so sensitive and so sacred, sexuality, that it is especially deserving of privacy, because otherwise without it, we're not gonna communicate. It reminds me of in RAV, where the court talks about threats against the president. It's an especially troubling kind of threat. So it seems like it's content discrimination, but if it's, for the reason it's prescribable, we can prescribe it. So I talk about it, but I don't hang my hat on it.
Well, I want to open this to questions soon, I think, but I want to have one more round regarding what I just mentioned, Danielle, right before we started, which is a development that's happened since her book was sent to the publishers, and that's the right to be forgotten that's now been recognized in the European Union. Is that, could something like that ever fly under American law? But even leaving that aside, is that a good construct for dealing with these issues?
Right, so the right to be forgotten, of course, the European Court of Justice instructs Google that they need to be sort of the arbiters of speech that should be, that it's not really newsworthy anymore. It's, in that case, it was news of a bankruptcy that was kind of old, the person, or was a debt that wasn't paid, that then was paid, and so it was old news at that point. And the search engine was instructed by the European Court of Justice to de-index the news article in a search of the individual name. So your question was, would this right to be forgotten fly under First Amendment doctrine? The answer is no way, no how, right? I mean, for all the reasons we were just having a spirited conversation about facts, generally it's protected speech unless it falls within a category or a set of, an understood area which is historically recognized as enjoying less protection. So, but we have seen we've seen a modified version of the right to be forgotten in some sense in FCRA, the Fair Credit Reporting Act, in which, we say, look, we're going to keep out of credit reports bankruptcies that are over 10 years old. So the idea isn't totally foreign. I think it's ill-advised to put in the job of arbiters of search engines or private companies, but rather there be like a form of
You proposed a Fair Reputation Reporting Act.
Well, something to think about, certainly, right? That is, it may be that, so when I think about Frank Pasquale's idea, it's in the context of private companies making decisions on their own voluntarily without order of a court, like the European Court of Justice, and whether there should be some mode of due process, right, which is voluntarily internalized, right? Companies deciding, as Microsoft did, I think, in a really progressive way, but providing lots of transparency. Jacqueline Boucher and Chief Stacy, also your client, right? You're going to say that Microsoft is another terrific client of Laura's, making clear how many requests I got. So I think it was like 500 requests, and they took down, 67% of them. They're making clear to the public, look, we're not having a rash of unfounded requests. It's not thousands and thousands, right? It's affecting an acute number of people, and we're making thoughtful decisions, and we're being transparent about it, about how we define non-consensual pornography. Microsoft's been very clear, and what they're doing about it. And I think that's the right way to go about it. But it's a private version. It's not a sort of federal, Fair Reputation Act in that way. It's private companies making, I think, decisions to be good Samaritans in a very clear and transparent way, which I applaud.
and which ultimately, hopefully, affects their brand, and people say, this is a thoughtful company, I do want my phone to be with them, I do want my email to be with them. If it's Microsoft, I do want to read this blog because it actually is curated and it doesn't have trash. And so hopefully, ultimately, you'll be rewarded for being a good citizen. And that would be the model that I would strive for. And we, in advising newspapers, there are decisions sometimes made where you decide to de-index stories, whether it's to protect a confidential source if there's a threatened claim, or because the person was extremely young and foolish, and you decide you want to, but that's an editorial decision not dictated by a court.
And is that why private companies generally have, and try to keep up to date their terms of service, because the marketplace will discipline them otherwise? They'll be seen as a disreputable brand or facilitating bad stuff?
I think so, but of course, there's a huge array, not everybody. And the other point is, the Googles and the Microsofts of the world can afford to have people making these article decisions. Google wants the right to be forgotten. They have a whole army of people reviewing this stuff now. Most folks don't have those resources. That's, another problem. I think you're basically forcing large companies can do this kind of work, but not necessarily smaller entities.
Speaking of Eugene Volokh, the Volokh conspiracy, I think each one of the individual bloggers gets to decide on their comment policies include a whole range of individual politics. Some have curated comments, some just disclose, I don't curate at all, but open comments have at it. Some say I'll have no comments whatsoever. Some do kind of a hybrid where they'll open it, but if there's too much that they don't have time for, they'll just close it at that point. What do you think about something like that? How would you advise that that's not a good thing, or it's on an individual level, do whatever's right, but the Volokh conspiracy as a whole might have to take a different tack, or the Washington Post, which now.
I mean, I think you have to look at who's coming to that site. I mean, you're not going to get revenge porn probably on.
I have no idea. We'll have to ask.
So,
there are female bloggers on.
And I think there are a lot of websites that have decided that they don't want anonymous posters. And there is a place for anonymous speech, and certainly it's protected. And as I said with my little school superintendent situation, that would be a reason for anonymous speech where you're commenting on, community development. Do I think that you probably get more responsible comments if you don't allow anonymous speech? Yes. Do I think it's easy to evade? Yes. So how useful it is, I'm not sure.
Sure. When you're going to SCOTUS Blog's live blog, which is probably the only one that I comment on or whatever, when they ask some big questions, right? Sometimes they just ask you to sign in with just your name. So most often I put in my name, but sometimes I just, to make a private joke to Tom or Amy or something, I'll do it while I'll just put in something else. And so I guess that's getting around the, I still have my name, but it's not my name. All right, questions from the audience, either here or in New York. Yeah.
Victor Cousins.
So I have a question about whether you worry about the extension of the heckler's veto in this scenario, and particularly with regard to private
I'll repeat the question if you can't hear it.
Private companies.
Okay. Mike's not here? Oh.
Can they hear me at all?
We can hear you.
We can hear you.
Thank you. Private companies establishing terms of service whereby they are taking down comments deemed offensive. Because what I've seen in the real world now is that there isn't a careful evaluation of the complaint, and instead the speaker's comments get taken down. They can be barred from posting again or speaking again on that site without really any due process at all.
So what's interesting about, when we think about the heckler's veto, when you have, with private companies, we have this immunity for them because we wanted to encourage it. This is the rationale behind the 1996, right, the Decency Act, which always makes me laugh. It's called the Decency Act, right, but it was meant to get porn off the internet, which is like a joke, right? But what remains, of course, is
Because as we know from Avenue Q, the internet is porn.
Yeah, of course, right? But, so the idea was we give them this good Samaritan whether they do nothing or are aggressively curating. And so we allow them to, of course, I guess that heckler's veto to me strikes me as like we have government intervention, and so we're going to have an overkilling of speech, whereas private companies, I'm just having that sort of dissonance moment, right? That is, we don't have government intervention because we've got this immunity, right? And so you have sites like the sites, Laura, you were talking about from your own experience, or the dirty.com, which say, we've got section 230, too bad, so sad. And I don't care if it's defamation or if it's revenge porn. You have sites that are devoted to revenge porn, and their operators are gleeful about section 230. They say, look, you know, we encourage access to post nude photos, right? And nothing can be done about it. Sue me, go try. And, you know, you can't because of section 230, and largely these claims have been dismissed. So, you know, you're right that some sites are aggressive with their terms of service and community guidelines, right? And it's disappointing, so I urge them on my book to be really clear about what they mean about, like, terms like offensive, and they shouldn't say offensive speech, but if they did, be clear about what you mean about hate speech, for example, which is totally protected speech, and allow for some modes of due process, right? Not just yanking people offline, but in a way, isn't that how the First Amendment operates? That is, when you walk into a private diner or a restaurant, if you start screaming at the top of your lungs obscenities at the waitress, you know, they can walk you out, right? Isn't that how we develop sort of social norms? And we're going to have some over and under curation, and in a way, that's how we want this marketplace to sort itself out. I guess I see too much of we have section 230 and we can let it all hang out and fly in our blog, and I don't care if it defames you, there's a privacy invasion or a threat, too bad, so sad, and victims find that they can't get jobs, they're undateable, unemployable, right? I sort of see less of that in the world in which I write about. That is, the heckler's veto, shoot, there's no veto. Like, they don't care what the heckler says, right? It's just, it's there for everyone to see.
Actually, I've seen victims of attack by complaint. In other words, people have been shut down because Twitter and,
yeah, like an abuse,
especially when you're talking about like secular bloggers,
yeah,
will get shut down when religious fundamentalists, and particularly in the Muslim world, complain of blasphemy.
Yeah.
And so you find that voices don't get heard as a result.
There's a question in New York.
Yes, I share Laura's, it's Victor Kochner, Davis Wright. I share Laura's concern about criminalizing speech, but I was curious why no one has identified what I think is the prime remedy, which is a civil remedy, and it's the tort, which many of these tables have gotten dismissed in other contexts with now difficulty, namely intentional infliction of emotional distress. Seems to me cyberbullying, which it can cover a number of the instances that Danielle led at the outset with, should be rather simple to prove an intentional infliction civil claim. Now some say, why bother with it? First of all, you don't have to depend on the police, who have a lot on their plate. It's one can do it privately, and it brings to mind that our firm about 15 years ago, along with Paul Weiss, brought the suit on behalf of Planned Parenthood on the West Coast against those who posted the Nuremberg files online. The Nuremberg files, you recall, were the photographs of those medical professionals who participated in abortion, and as some were assassinated, X's came across their photos. We won that claim against a fierce First Amendment objection, sustained substantial judgments. Of course, the people who put those files up, not surprisingly, were not people with substantial assets. However, their wages were garnished for years thereafter. I can't think of a more satisfying, long-lasting lesson than the garnishment of wages, and I don't want to leave the Planned Parenthood subjects without drawing people's attention to the recent development, not in Texas, which has gotten the most attention, where the perpetrators of those altered footage involving discussions of fetal tissue where charges against them were dismissed and brought in Texas. I think it will fail, criminal charges. But in California, there's a massive complaint against them with a whole series of torts asserted, not all of which would apply to the kind of intentional affliction, but some are in there. I would watch that case, because those people who did that may not be headed for jail in Texas, but they're headed for bankruptcy or for years of having their wages garnished. So it seems to me we have existing civil remedies which ought to be examined very carefully. And can you get law firms to do it? Well, there are a lot of...
I lovingly talk about,
Yeah.
Intentional infliction of emotional distress, public disclosure of private fact defamation. No, I believe me, in my book, I didn't get to give my whole spiel about, the book. I wanted to spare all of you, but no, I talk about, of course, tort remedies, criminal, as well as civil rights law, ways in which we can use all of these remedies. The problem that victims often have, though, is, of course, how expensive it is to sue. And lawyers often won't take these cases on contingency because, as you aptly note, there really isn't a deep pocket given Section 230. So, but we have groups like the Cyber Civil Rights Legal Initiative, which is K&L Gates, is now taking pro bono cases involving cyber harassment. Like within a week of announcing that they had this legal initiative, they had 100 cases. So they had to like close up the pro bono effort, right? They could only take 100 cases, but I hope that everyone in this room, practicing lawyers, would consider taking pro bono civil matters, because I think you're exactly right, that if we could get civil remedies against someone, even if they don't have a deep pocket, but they have to think about it, right? Garnishing their wages strikes me as would be so incredibly satisfying to all the victims that I write about in my book. So absolutely, I'm totally with you, and sort of explore their First Amendment implications in the book as well.
Well, I was going to say the cyberbully that I mentioned is the subject of a $17 million libel verdict. And as Victor knows, you need the kind of outrageous conduct that, is a very high bar for intentional infliction for a good reason. There's not necessarily falsity involved. I think, and another question that you raised in your book is, should there be Jane Doe, John Doe lawsuits available and for those who don't want to put their name out again and maybe face even more bullying? And I think in those cases there should be Jane Does. Obviously, there will be the defendant will at some point in time know who it is and be able to use them, and that's part of the risk. But I think at least initially they should be able to bring Jane Doe cases.
You got it first.
Yes. So I'm interested, you started off the conversation talking about, the blogger who's been attacked by, these kind of broad-based attacks. And I think we've kind of moved to talking about an identifiable harasser, which I think the law is much more suited to dealing with, whether it's from an IAD tort claim, whether it's from copyright. What do you propose when you have this kind of the mob of the internet, where there's not a person, there's a distributed swarm of sock puppets? It could be one person, it could be 10,000 people, and you don't even have a defendant. Like what would be the remedy there without over criminalizing, but also, shutting down these very important forms of free speech for everybody, because you have these bad actors.
And the sort of cyber mob is what motivated the project itself. Right?
Yeah.
That is, whether it was attacks on female law students on a site like AutoAdmin,
Yeah.
or it was Kathy Sierra, right? Those kind of anonymous cyber mobs, and the way in which it's the totality, but each individual actor likely isn't responsible criminally, nor are they probably not for IIED. You need this sort of sustained, outrageous behavior by a single person, when it may be that death by 1,000 cuts, right? Those are the hardest and most complicated. You see it in Gamergate with Anita Sarkeesian, where it's like thousands of people going after Brianna Wu and Anita Sarkeesian, all these women who, create video games, right? All because they dare to talk about sexism in video games, right? They face death and rape threats and doxing and swatting, and it's really hard to get at the crowd. Almost as Anita Sarkeesian explained to me, and it's in the book, she's like, what do I do? What do I say to law enforcement? It's thousands of people.
Right.
Am I really expecting them, right? And that's where I think law really breaks down. It's too blunt an instrument. And that's where I think the private actors curating, as Lawrence, you were saying, like using their ability and freedom to curate, I think is where we're going to have the sort of the most targeted sort of response, because those swarms are law's way too tough an instrument. It just isn't, it's not fine-tuned enough for
But
that.
then they use their fortune. I mean,
Oh, yeah, and they do, right?
Right.
Oh, yeah, and Encyclopedia Dramatic and all the
Right.
fun trolls of the universe, they have subreddits and, right?
4chan is the one that published the celebrity news.
Yeah, right.
Years ago.
Yep. And those are tough questions.
To me, the really fascinating legal issue about all of this is it forces you to determine, as Ilya was saying earlier, why is this particular speech versus that particular speech not protected by the First Amendment or protected by the First Amendment? Going to the intentional infliction thing, is it merely the Snyder versus Phelps test? I mean, is there this, very kind of speaker-friendly definition of what's a matter of public concern? And if it satisfies that test, Katie bar the door, there is a First Amendment right to do this. Or is there something about the medium that would make you want to identify a category of unprotected speech that covers this, but wouldn't cover it because in another medium because it somehow relates to a matter of public concern? And how do you deal with all of that in the context of a Supreme Court that's pretty much indicated we're not in the business of creating new categories of unprotected speech? And when you get out of areas that are relatively simple, like threats, how do you fit these things into an existing category without screwing up the category as it currently exists? Or is there any realistic prospect of creating new categories? And if we can't do either of those things, are we comfortable saying we've got to tolerate a certain amount of this to keep our general regime of free expression the way we want it to be?
And I think I sort of came down with a very conservative, careful, hewing very carefully to what the categories we have and speech that historically has enjoyed less rigorous protection for the very reason that it's true that network technologies tend to spread far and wide. It's sort of like wildfire, really destructive information, but same with really positive stuff, right? So that it's true that the medium itself has an exacerbating effect, right? Because it's searchable, it's persistent, it's the first thing you see in a Google search of many victims' names, right? It makes it really difficult if you have to put in a cover letter that you're a victim of this abuse and that you didn't really post the nude photo of yourself, right? Or sort of generate this, have a reason for it, the lies about you. No, I don't really have herpes. No, I'm not a prostitute, right? But those same things that can make the abuse so spread like wildfire and have such a powerful impact on people's lives are also the domestic, you think of all the speech that's there for all the great reasons. But I'm hesitant to suggest new categories or think of the medium as something exceptional, because there's also the really positive exceptional things about it. I guess I'm saying what you probably all would, of course, say yourself. But I think I was reluctant for that reason to suggest that we depart from a very conservative approach that, and I didn't want to create new categories for the internet, so to speak, because what's next is not the internet, but something new and even more embedded in our lives. The Internet of Things or the security of things is, we're going to have troubles along so many different dimensions.
I think one thing you do see courts doing, and this is another thing I think would be good, is sort of educating the public on how to read what they see on the internet. I mean, I'm thinking about if an employer, Googles me and sees what is up there and says, oh, I'm not going to hire her because of that, I don't want to be employed by those people. And you need to educate, the readers, and the courts have said, you know, people understand, you know, what's on the internet is not necessarily the same as what's in, you know, print newspaper where they've worked for, you know, hours and days versus a tweet that is wrong and, you know, links to the story, but it itself might be a mistake, and there's kind of reading all this in context, and I think, you know, educating the public and the lawyers and readers how to read what they see on the internet in context is a big part of the process too, and courts as well.
And educating clients, I don't think lawyers actually, having interviewed many for the book, they don't actually believe that, you know, the lies and the privacy invasions, right? It's just that they hesitate to hire someone because they don't, A, want the person who comes with baggage, so they're distracted by dealing with harassment and stalking, and they don't want their clients to think they hire someone who's disreputable, right? So I don't think they believe this stuff, it's just that they're cautious in a world in which we have abundantly lots more people. There's more people, less jobs, and there are so many more people. You pick the person who doesn't have this kind of service to deal with.
Kind of what?
Sorry, service, like
Illegal.
Yiddish. Sorry, from New York. You know, like stress and sorry. Yeah.
Can I just say one more thing?
Sure.
The other observation I wanted to offer and maybe get some comments on is the other tort that obviously has some applicability here, which is you mentioned is publication of private facts. And as you said, the Supreme Court has, you know, assiduously avoided ever saying whether or not the publication of private facts tort can exist, at least in the context of a world in which there's some newsworthiness or public concern involved. But I wonder at the end of the day, you know, you were talking a hypothetical about Ron, all of a sudden he's a public figure, so that the discussion that he had about private matters, you know, which you said would be protected speech. I wonder if ultimately when the court does get there, or when even lower courts start working this out, they don't go to a kind of European model where they balance the degree of the intrusiveness or the ugliness of the privacy invasion against the level of public concern and make kind of a proportionality judgment about which is more important on the facts of each case. I'm ashamed to admit it because I generally don't like the European approach, but I'm starting to warm to that notion as really the only way out of this box.
I'm willing to, go ahead.
Well, to Lee's point about the publication tort, before the internet, there were a ton of cases on what is essentially non-consensual porn, where exes would distribute pictures. Of course, back in the old days, it was actual pictures on the internet. But they would distribute pictures of the exes, and
Stand on a street corner, how
They'll
do
put it on
they
people's
put on windshields in the car,
Totally, yeah.
or mail them to bosses or things
Yeah.
like that. I mean, there's tons of cases on this. This is not a new problem. And the courts have universally said that if you're like a regular person, not Hulk Hogan, aside Hulk Hogan, I'm with you on
I
that.
wanted to ask about Hulk Hogan because
But if you're a regular person, this happens to you, the publication of privacy tort, publication of private facts tort applies because it's private information, sexual information and nudity is private, and it's not newsworthy because you yourself are not in the nexus of a newsworthy matter. I don't understand why this is different. It should be the same analysis. And for some reason, everybody thinks, well, it's the internet, so it's different. And I don't see why the medium changes that analysis. But what's worse is that when advocates are trying to take the privacy tort and turn it into a criminal statute, they mess with it too much and make it, I think Laura's concerns about over-criminalizing are that when you try to turn it into a criminal statute, you have multiple problems. One is you need an intent requirement, and you could add an intent requirement without too much difficulty and maintain the integrity of it, and it would still work. But the other problem is that you start running into all these other requirements that they want to put on it, that you have to have known the person, you have to have known of the expectation of privacy, or you have to have like done all these other things, or they try to tie it to copyright, or they try to tie it to the number of people you've disseminated it to. And it seems like you lose the essence of what was meant by the tort when you try to get to fit a particular scenario, like a particular one of your anecdotes, and you take the tort and try to make it fit that anecdote. instead of letting it be what it is, which is facts that are private, which nudity is, and even though nudity alone is not an unprotected category, it doesn't mean it's always protected. I mean, the Supreme Court has said indecency is not protected if you can meet the strict scrutiny test. And so if you have a compelling interest, which you do, and there's no other way to remedy it, which it may be true in this case, and you have the intent requirement, and it's not newsworthy, that's the statute. I don't understand why it's not so difficult. It should be relatively straightforward.
And why layer on an incentive with emotional distress like the California Urban Statute? Or reasonable expectation of privacy, which itself, we know in the Fourth Amendment, can be difficult to spot that with them.
Right. But the problem is
actually complicated.
the interpretation has to hew to the newsworthiness standard as it's already been established. I mean,
Right. We don't need to build it into the statute, you're saying, right?
Yeah, we don't need to
It's
prosecute
there.
everybody who draws naked pictures. It's really a question of, is it truly a private fact, and is it newsworthy with the interpretation we've already had? The balancing just doesn't seem necessary to me.
I have a question here in New York. I was at a public university a couple of months ago, and they asked me the following question that I would ask you guys, which is, parent comes to an administrator and says, my daughter, a student, has gotten a lot of social media, a lot of emails that's gone all over the school saying that she's a slut and worse, calling her all sorts of racist names and worse. My daughter has stopped going to classes, is very depressed, and I'm in fear is going to harm herself because she's so shocked by all the social media about her. The administration says, well, we went to our lawyer, and they say, well, we can't do anything because it doesn't appear that there's any incitement of imminent lawless action. There's no substantial disruption of education in the classroom. And anyhow, the school maybe can't even get involved because none of this took place on campus. It's all written on computers in the students' homes. But yet, we don't want to do nothing because what if the student kills herself? Then we're going to look awfully bad from a PR point of view. We're going to get sued for negligence, and by the way, we don't want students killing themselves. What advice would you give that administrator?
I feel like I've been asked that question by administrators, right? And thankfully inside of schools. No, I guess so I'd say.
No, this is a public school. That's the whole point of the question.
So it makes it more complicated, right? We know that courts are sort of
This is why we need
the
school
map on
choice.
this, right?
There was their Cato moment.
It had to come.
We know that, courts aren't clear in their message in lower courts about what schools can do, like can you punish for speech that occurs off campus, if not the kind of disruption that we can sort of think of as disruption. I think what I would urge schools to do is have sustained, I've urged schools to have sustained and ongoing conversations with students about, so rather than intervene in an individual case and have punishment, but have an ongoing sort of long-term devotion to lessons of digital citizenship, to the harms of harassment and bullying, to have sort of community moments in which you talk to your students, not once and done, because that doesn't do very much, but have real, ongoing, sustained conversations with families, parents, and students, and that parents can't get off the hook and ignore what their kids are doing, but rather through education is how I've advised both private and public schools to address this. And I don't know.
I'm looking at Lisa Zykerman, and my colleague who actually does a lot of school.
So we need data. I
But I feel
barely touched
I mean,
this
the
stuff in my
scenario
book.
that you're setting up is one that I'm imagining in a secondary school. I'm not imagining it at a public university. Have you advised
Right.
universities to
Oh, I'm
sort of
talking about
rally?
secondary schools, like
Yeah.
high schools.
I mean, the interruption to the educational environment and the special relationship that public secondary schools have with their student body is completely different in the public university setting. And I think that was George's voice I heard. The example that he's providing here is one where you have a school administrator who has absolutely no responsibility for off-campus speech and has limitations under the First Amendment as to what punishments or limitations they can put on student speech that occurs on campus or threats made on campus unless there's actual threat of bodily harm.
And so yes, you can have ongoing education and discussions, but what parents are you bring? You can't bring parents in, right? And it's really about these adult students and how they conduct themselves. And this reminds me of Yik Yak and other social media platforms that are on public university campuses, where students anonymously or non-anonymously can post comments that many have viewed to be threatening, sort of that mob mentality writ large in a social media platform, and is that the university's responsibility to moderate, or Yik Yaks or otherwise? In disclosure, we do counsel for Yik Yaks, so it is a very complicated, weedy area.
Well, what's interesting, thinking about Yik Yak, Colgate University, it's a private university, but I think it's sort of great. I have a kid who's going there in the fall, so I'm biased, but it's had a great response to it was really hate speech on campus about a year and a half ago, but faculty went on Yik Yak and voted down really destructive speech, got involved in the conversation on Yik Yak, became part of the kind of solution to make students feel safer. Now, they didn't do a perfect job, as they'll admit, but, I think that we're in a tough spot too, even though I imagine as a private university, they could have done whatever they wanted, right? But I think they chose to be part of the sort of making students feel safer by part of voting down some of that speech.
That would be a great outcome. Not all public university professors feel safe in their own job security to put themselves forward in a very personal way.
Yeah, comment from New York?
Yes, I did want to try to respond to George's question with the question one. If the student were if we're talking about secondary students in a private school, there's no question that they would face discipline and expulsion after warnings. If there were in a charter school in the city of New York, that would also happen. And only the children in public schools appear to be without those same protections, which warrants, it seems to me, further review. Although I think there are curricula devoted to this very issue in which classes focus on it, spend time on it, which is, I think, the better way, but I don't know why public school children shouldn't. And I think even in public schools, if a child is disruptive in the New York City system, they may be transferred to a special school, and I don't know why that has to be limited to physical violence. I think it could apply to this kind of cyberbullying as well. And if it is, it will be reduced dramatically.
Yeah, I think it's relevant for the context of young adults doing this behavior, but also in response to why is the internet different? I think it really comes down to impulsivity. And with the young people are impulsive. The court has recently held that for death penalty in the death penalty context. But, I think a balancing test is more appropriate in this area just because the impulsivity factor and the retweeting factor, the single click ability, there's more of a disconnect than printing out pictures and putting on people's cards or sending it to a boss.
So can I ask about Hulk Hogan? So we just talked about public versus private. We talked about, all these different things. How is it that Hulk Hogan is going to apparently destroy Gawker now? And is this a good thing?
The answer is he won't, because the answer is it'll be reversed on a few.
Not just reduced, it'll be reversed.
I believe it'll be reversed.
There is a little fly in the ointment. I gather that they have to put up a bond of $50 million in order to take an appeal.
But they can challenge, as I understand it, they will be challenging whether they have to put up that $50 million bond. I don't know how successful that will be.
Is the Hulk Hogan case different than the Aaron Andrews case?
Yeah.
Yes.
If we're just going to leave it with a yes.
I think
It's totally different. I mean, Gawker didn't just receive the tape. This other guy, the peeping Tom who screwed around with a peephole and took the film himself. I mean, there's obvious difference. I mean, I read one article that shows that women still haven't made a mark because she only got 55 million and he got 140 million. I don't think that's a terribly cogent analysis.
She's more likely to get it.
She's more likely, oh yeah, she's gonna win. She'll have it sustained. I agree. I'm doing an article for the MLRC law letter that basically whose postulate is that Hulk Hogan and Donald Trump are really the same person. So you can
Whoa.
Maybe Donald should start wearing his hands.
And Trump, Terry Bollea, or Hulk Hogan?
I just wanted to make a comment. We've been talking a lot about categories of protected speech and unprotected speech, and that's been the formula ever since Shaplinsky down through a case that Paul successfully argued, Brown versus Entertainment Merchants Association. And typically the court lists from 5 to 6, 7 exceptions over the years. But when I counted them, I counted 43. Now, it may be that some of those 43 could be lumped under the 6, which might bring us down to 30 or even 25 or even 20. But suffice it to say that there are a lot of categories of, quote, unprotected speech that day in and day out are litigated that are not listed. And in fact, I think Shaplinsky and the other opinions say, among others, but the emphasis by talented lawyers like my colleague here, Paul Smith, emphasized the 6, but practically speaking, that number is far greater. Even if we say some of them are redundant and we bring it down to 20 or even 15, there's a lot of torts and criminal actions that go on, prosecutions day in and day out, beyond the 6 limited that the court has mentioned. I hope that doesn't get me thrown out of the salon, but just an information. So are we? All right, so in New York, unless you have any questions or comments, this is your final opportunity. If not, would you please?
Read the book. It's very good.
I concur in that. Will you please join with me in thanking Danielle Fischer, Julia Shapiro for doing a really good job, and Laura Hammond likewise. And thank you all. And the next time we see you will be with Jeffrey Stone and Richard Posner live from Chicago. Thank you all.
Right. Sure.